Hello, I'm Magistrate Michael Douglas. If you are the parent or guardian watching this video, the information being provided is important for you to understand as well. Throughout this video, I will be speaking to your child directly. However, it is important that you also fully understand these advisements and rights explanations. Please pay close attention. When your child appears before the judge or magistrate, you may be required to answer questions or provide information pertaining to your child's case. As the parent or guardian, your complete understanding of these matters is crucial, so make sure to listen carefully to everything I am about to explain. If you are the child, you are here today because the state of Indiana has filed a petition alleging that you committed a delinquent act that is a crime when done by an adult. The court has reviewed the allegations and has authorized the filing of the petition. Both you and your parent or guardian should have received a copy of the petition the state has filed. Please tell the court staff if you did not receive the petition. The petition outlines the allegations that you, the child, committed a delinquent act, which the court will explain later. It is crucial that you understand the nature of these allegations made against you. The purpose of this video is to advise you and your parent or guardian of certain rights and the nature of the allegations in the petition filed by the state. If you have any reason to believe that you qualify under federal law as an Indian child, please let the court know. This means that you are either a member or eligible to be a member of a Native American tribe or Alaskan Native village. If this applies to you, please notify the court when you appear before the judge. Because the state has filed a petition alleging that you committed a delinquent act, you are entitled to certain rights under the law. It's important that you fully understand these rights as your case moves forward. I will now explain them to you. You have the right to be represented by an attorney. You may choose to hire your own attorney, or you can ask the judge to provide you with an attorney. If the court appoints you an attorney, the attorney will be provided to you without any cost to you or your family. You may waive or give up your right to an attorney, but only if certain conditions are met. You must knowingly and voluntarily waive that right. This means you must understand what you're giving up, and you must choose to give up your right to an attorney on your own, without anyone pressuring or forcing you to give up that right. Additionally, you must have had a meaningful opportunity to consult with your parent or guardian about waiving this specific right. This means that you need to have a real chance to talk with your parent or guardian about whether you should or should not give up your right to a lawyer. Lastly, you yourself must knowingly and voluntarily agree to waive your right to an attorney as well. All these requirements must be satisfied before your parent or guardian can validly waive your right to legal representation. Before you can waive your right to an attorney, the court must make sure you fully understand what you are waiving and voluntarily waive that right. If there is any possibility that these hearings could lead to your removal from your home, you must meet with an attorney before waiving the right to have an attorney, and the waiver must be stated in court and must be filed in writing. Additionally, your parent or guardian or your attorney must agree with the waiver of that right. They must have no interest adverse to you and must discuss what it means to waive that right with you privately. All these requirements must be satisfied before you and your parent or guardian can validly waive your right to legal representation. If, after all of that, you decide to waive your right to an attorney, you should know that you can change your mind and request an attorney at any time during these proceedings or at a later date. Because the state has filed a delinquency petition against you, you have certain rights in these proceedings, which I will now explain. If, after this video, you do not fully understand one or more of these rights, please let the judge know. If you have an attorney representing you, be sure to speak with them first and ask any questions you may have. You have the right to an attorney who will represent your interests, not your parent or guardian's interests. You may hire your own attorney, or if you or your parents request it, the court will appoint one for you at no cost. You have the right to consult with an attorney and have one provided at any hearing where detention is a possibility. You have the right to remain silent. No one can force you to testify or give a statement. While you are entitled to be heard in your own defense, you should understand that anything you say can and may be used against you at a later hearing. You have the right to deny the allegations against you. You are presumed innocent unless and until the state proves the allegations beyond a reasonable doubt. If the state is unable to prove that you committed the allegations, the case will be closed and you will not suffer any further consequences from this case. In juvenile court, there is no right to a jury trial. Instead, you will have a trial called a fact-finding hearing in front of a judge or magistrate. You have the right to see, hear, and question all witnesses presented by the state. You also have the right to present your own witnesses and tangible evidence. The court will assist you in doing so by issuing subpoenas and ordering any witnesses you want to appear and testify on your behalf, and by issuing any orders necessary to help you gather evidence. The judge will ask you later if you understand these rights and if you have any remaining questions. Now that I've explained your rights, it's also important that you know what could happen if the court finds that the allegations against you are true. If you are adjudicated a delinquent child, you may be required to participate in a program of care, treatment, or rehabilitation. That program could include community services, counseling, probation, home detention, placement in another home, placement in a non-secure or secure residential facility, detention in a secure facility, and commitment to the Department of Corrections. Your parent or guardian may be held financially responsible for any services provided to you. The court has various dispositional alternatives available, from probation to placement at the Department of Corrections. You may receive a list of these alternatives, read them carefully, and ask any questions if you have any. To aid the court, the probation office will submit a predispositional plan, but you may also submit your own plan for your rehabilitation for the court to consider. You may admit or deny the allegations of the petition and that you are a delinquent child. If you deny the allegations, the court will set this matter for a fact-finding hearing within 60 days. However, if you are in detention, the court will set the matter within 20 days. Weekends or holidays are excluded from these calculations. Alternatively, if you decide to admit the allegations and that you are a delinquent child, the court will proceed today with an admission hearing. If you wish to admit the allegations, you understand that by doing so, you are waiving or giving up all of the rights I have explained. You will not have a fact-finding hearing, and the state will not be required to present any evidence proving that you committed the allegations. You will be required to testify against yourself. If you haven't spoken with an attorney, admitting means waiving that right, and you must first talk privately with your parent or guardian. If you decide to waive your rights and admit, the judge will ask you whether you fully understand your rights and that you are giving up those rights. You have the right to discuss this matter with an attorney before deciding whether to admit or to deny. If you are asking the court to appoint you an attorney, the court will do so. I will now explain what will happen if you decide that you wish to admit the allegations today. You do not need to admit to the allegations today, but you will be asked later if you wish to. First, if you decide to admit to the allegations and that you are a delinquent child, you must understand and agree to the following. 1. No one may threaten you or promise you anything to get you to admit. 2. Your admission must be of your own free will and be voluntary. 3. If you admit to the allegations and that you are a delinquent child, you must understand that the court could move to immediate disposition or set this matter for a subsequent hearing after a report has been filed by probation. If you intend to admit to the allegations, the judge will ask that a factual basis be made. A factual basis is a process where the facts that led to the filing of the delinquency petition are read out loud or stated in court for the record. After the facts are read or stated in court, you will then be asked if the allegations are true. If the judge determines that a factual basis has been made and accepts your admission, the judge then will move to adjudicate you a delinquent child. The court will then order the probation department to prepare and file a predispositional report. The court will also schedule a hearing at a later date to determine the disposition. The next section of this video applies only if you have been taken into custody and are currently in detention. If you are not presently detained, what I'm about to explain may not apply to you. If you are in detention, the court must first determine whether you should continue to be detained or if you should be released, potentially with certain conditions that you and your parent or guardian will need to agree to. To continue your detention, the judge must make specific findings that at least one of the following applies. You are unlikely to appear for subsequent proceedings. Detention is essential to protect yourself or the community. Your parent or guardian cannot be located or is unable or unwilling to take custody of you. Returning you to your home is or would be contrary to your best interests and welfare and would be harmful to you. Or you request not to be released and you have a reasonable basis for that request. Next, if the judge determines that you should continue being detained, they must then decide where you should be held and what responsibilities, including potential financial reimbursement, your parent or guardian might have. Lastly, if the judge decides that you should be released from detention, they will determine what, if any, terms or conditions will be set for your release. As a reminder to the parent or guardian watching, if your child is adjudicated delinquent, you could be required to repay the cost of any detention, other placement for your child, court-ordered services, or a portion of those costs based on your financial situation. This will be addressed at a separate hearing regarding financial contributions. Your parent or guardian will have the opportunity to provide suggestions to the court concerning your detention status today, as will the state and the probation department. This concludes the advisement of your rights. If you have any questions, please ask them when you are before the judge. Thank you.